video, I'll be discussing the rules on intestacy and what it means to be intestate. This is the first video in the SQE series for wills and the administration of estates, but if anyone has any specific requests on any topics, then I'm happy to cover them in a separate video. Just comment down below. So I think it's important to go through a couple of key words, and the word that is used consistently throughout wills and the administration of estates is the succession estate, which simply means assets capable of passing under a will or by intestacy. Starting with testacy. Testacy is where the deceased will covers their entire succession estate, and only the will is relevant when determining how to distribute their succession estate. Intestacy, on the other hand, is when a person dies without making a valid will and is said to have died intestate. The intestacy rules apply to their entire succession estate, which is what I'll be discussing during this video. Partial intestacy is in circumstances where the will does not cover the entire estate and the deceased is partially intestate. Partial intestacy often arises as a result of poor will drafting rather than intentionally. The will is followed, but the intestacy rules apply to any remaining property left out of the will. Firstly, there are certain types of assets which cannot pass under the succession estate, and that is donato mortis causa, discretionary pension scheme benefits, insurance policies written in trust, statutory nominations, property held as beneficial joint tenants, and some other beneficial interests under trust, and property held in a trust. I'll start with donato mortis causa. A DMC is a gift made in contemplation of death. It is an inter vivos gift, by which the donee is to have absolute title if the donor dies. However, a valid DMC has 3 requirements that need to be satisfied. That is, the gift is made because the donor believes they may die imminently of a particular cause. The donor makes it clear that the gift is conditional upon them dying, and that the property reverts to them if they survive. And lastly, the donor either parts with the property or something representing ownership of it. The second asset, which is not in the succession estate, is discretionary pension scheme benefits. This could be where the deceased was a member of an employer's discretionary pension scheme, and payments made by the trustees will not be included in their estate for distribution purposes. And these rules only apply to discretionary pension schemes. Some other pension schemes may pass. So as you can see on the slide, payment is entirely at the discretion of the trustees. The deceased is not deemed to have any entitlement to any payment from the scheme, and it can be released upon the production of a death certificate. I'll now go on to insurance policies. If the deceased has a simple life insurance policy which wasn't written into trust, the proceeds of the policy will pass to the succession estate. However, if the benefit of the policy was written in trust for another person, the proceeds will not form part of the succession estate. The insured has no beneficial interest under the policy. The proceeds belong to the beneficiaries nominated in the policy and vest on the insured's death. And life policies can be written in trust in 3 different ways. So they can be written in trust under Section 11 of the Married Women's Property Act 1882 for the benefit of a spouse or children. It can be expressly for the benefit of any nominated third parties, or into any existing trust for the benefit of the named beneficiaries in the trust deed. We also have statutory nomination, which are assets that a person owns and can dispose of by nominating a beneficiary when they die. This is usually by making some type of nomination to the body holding the asset. The asset would pass directly to the beneficiary as soon as the body holding the asset is informed of the death. A person can make a nomination in a friendly society, industrial society, or provident society account. However, do note that there is a £5,000 limit. We also have property held as beneficial joint tenants. So if you study property law, you will know that property can be held as joint tenants or tenants in common. If the deceased was a beneficial joint tenant, the property will automatically pass to the other joint tenant by survivorship. It therefore does not pass into the succession estate. However, if the deceased was a beneficial tenant in common, they have a separate share in the trust property which is not extinguished upon their death. This share will pass into the succession estate. Therefore, joint tenant shares go to the other joint tenants, and tenants in common share pass under the rules of intestacy. And this is the same for bank accounts too. If the bank account is held jointly, then it will not pass into the succession estate. And if the deceased owned a sole bank account, then it will. Moving on to entitlement. So usually the succession estate will pass the deceased spouse or issue. If there's no spouse or issue, then the statutory priority order of entitlement will be followed, which is set out in section 46, which I'll go through later on in this video. Issue means children or grandchildren, includes those who are born to married or unmarried parents, or born to unmarried parents who later marry. Also adopted children. It also includes children who are conceived but are not yet born at the date of death. And a spouse or civil partner in this case means married partners. It does not apply if they're unmarried. And as you'll see on the slide, there are certain rules with spouses and issues where they have to survive the deceased by 28 days from their death. So if the intestate leaves spouse and issue, it will be distributed like so in the table. So the spouse will receive personal chattels, absolutely, a statutory legacy of £322,000, which is 3 of tax and interest, and 1/2 of the residue, absolutely. And the issue will just receive the other half of the residue on statutory trust. If the intestate leaves just the spouse and no issue, then the spouse will receive everything already in the table, but they will receive the whole of the residue. And if the intestate leaves issue but no spouse, then everything will go to the issue on statutory trust. Personal chattels. So there's a statutory definition of personal chattels. It means tangible, movable property, but it excludes the following: money or securities for money, property used by the intestate at their death solely or mainly for business purposes. So for example, this could be a company car. Property held at the death of the intestate solely as an investment. And this investment exclusion can sometimes be ambiguous, which is something you need to look out for in multiple choice questions, as sometimes the deceased may say have purchased a painting for an investment purpose, but they had it up on their wall and admired the painting and possibly have no intention of selling it. So then it may not pass under this exclusion. So you need to be careful with this one. What if the issue is under 18? Well, say if the child's parent died without leaving a spouse, would they be able to inherit a house if they're under 18? Well, the standard rule is that the beneficiary must survive the intestate and reach the age of 18 to inherit. If the issue is under 18, the beneficiary has what's known as a contingent interest. This means that their entitlement is contingent, aka subject, to them reaching the age of 18. It may be held on trust until they've reached that age. But if the beneficiary is already 18 or older when the intestate dies, they will inherit absolutely and immediately. And as the contingency is already satisfied, they will have what's known as a vested interest. There's also a substitution limit, which is used in circumstances where if an entitled beneficiary dies before the intestate, that beneficiary's own issue can inherit in their place, provided the beneficiary's issue themselves reach the age of 18. So for example, if a mother's daughter died before the mother, but the daughter would have inherited the succession estate if the mother died, the succession estate could go to the daughter's issue, if that makes any sense. So distribution where the intestate dies without leaving a spouse or civil partner or issue. So if the intestate is not survived by their spouse or issue, section 46 sets out the following order of entitlement to the succession estate. So you'll see we have parents, siblings of whole blood, siblings of half blood, grandparents, uncles and aunts of whole blood, uncles and aunts of half blood, and if none of the above, if the intestate died with none of the above and neither they had a civil partner or issue, then it will go straight to the Crown. And as you'll see at the bottom, where there is more than one person in the relevant category, then the succession estate is divided equally. So this brings us to the end of the video. So the purpose of this video is to provide a brief overview of the succession estate and some of the intestacy rules. I have the SQE assessment objectives here, and as you can see underlined, we've covered the distribution of intestate. And we've mentioned partial intestacy, but I'll cover this in a further video. So comment down below if you'd like any videos on any specific topics and I'll do it. But thank you for watching.